as my pal Jeff Verdon states, is I'm billing. So we have a lot of ground to cover today. It's going to be exciting webinar. Appreciate everybody. I see a lot of names. A lot of you know each other. There are some new names, so I'm looking forward to getting to meet everybody. My name is Ray Olmo. I'm the CEO and president of TRUST-CFO. We're the largest administrator for private retirement plans in the state of California, as far as I can prove. And it's been a great pleasure to work with a lot of you there on the phone. Today, what we're going to do is we're going to offer a win-win. We're going to make sure that we tackle a topic that most of you have had a taste or basic understanding of private retirement plans, but some of the concepts have been a little elusive. So I worked diligently this first quarter to formalize these things. As a lot of you know, I'm pretty good at the grease board and boxes and arrows, but we have actually built some modeling, and we're going to show you the dynamic and the power of a private retirement plan when it's properly constructed. You're also going to be awarded some continuing education credits or a credit for what that's worth, and Derek will make sure that you get those credits after the presentation tomorrow. So in moving forward, I have a lot of ground to cover. Let's do some housekeeping. First, I'm going to cover, again, 3 main key secrets. I'm going to try to do this in about a 45-minute, might be a smidge longer. I want to make sure that I cover the topics. That's the most value. If I go a little over, my apologies, but what we'll do is we have plenty of time to field questions after and through email. My email is listed below, and again, that'll be rehashed. So let's jump into it. What we're going to do is we're going to talk about the California Private Retirement Plan. For those of you that don't know, it's actually California statute, a law, a California Code of Civil Procedure, and it has a number 704.115. If you're not familiar with this, please look that up and please read it. It's extremely short and extremely potent. And if you'd like to have that deciphered, again, we work with a lot of great attorneys that can help you with that, and we'll match you up. Okay, let's look at what the key value is, or the key points of the law are. Number one, it's been a California exemption law since 1970, actually when it's originally formulated, and it got reaffirmed later. But if you want to look at that law, it's been around for nearly 50 years, and it actually came out 4 years before 1974, when ERISA was created on a federal level. So California actually had created something wonderful, and it hasn't changed since. What it does say is it focuses on 3 things, which is a private retirement plan. All funds, so monies that go into the bucket, are exempt. All distributions are exempt, and that's where clients really get excited. They go, wait a second, even when I take it out of the bucket? Yes. And all death benefits are fully exempt from creditor seizure and attachment. There is a condition. It's very specific, and there's 186 plus case laws, I think more now, that have made this very black and white. Only if you can prove the need for retirement and it's been properly administrated. And we're going to talk about what those requirements are. In the recap of the value of what we're trying to perform with a private retirement plan, we've identified that it really is the safest and the strongest and becomes the cheapest form of asset protection because it falls under exemption law. And we're going to talk about the Uniform Fraudulent Conveyance Act in California. Safest, strongest, arguably, I actually would make the statement that qualified plans, a qualified 401k or profit sharing plan is even stronger pension plan. But as you guys all know, that it gets exhausted quite quickly with the wealthy. It's like throwing a deck chair off the Titanic and they don't get a lot of benefit. Let me focus in on this word cheapest. When I say cheapest, I don't mean that our clients don't write our great attorneys and us large checks. What I mean is that we're maximizing the values, and we're actually creating a profit center, not a cost for our clients. So they're actually, through some of the tax exemptions and creditor exemptions, making money. And that's a great proposition, and I want everybody to be able to use that. One of the reasons it provides the safest, strongest dynamic is because it is the only plan that actually tactically harvests all forms of taxation. Let me make sure that we're clear on this. Things like other retirement plans, like qualified plans and IRAs, actually what they do is they reform the taxation. So when you fund a qualified plan, you now have a tax deduction going in. It becomes tax-free or tax deferred as it accumulates, but then it's ordinary income tax as it comes out. So what happens is you can take a capital gain asset like real estate and actually taint it tax-wise if you're not careful. And so again, what we're going to look at is that we have the ability to harvest ordinary income tax, passive income tax, and even capital gains tax. So all forms, very powerful. And tying into that, it is also the only plan that leverages banking. As an ex-banker, founder for a community bank locally, I'm savvy on things like loans, liens, financing, and so we've developed those specialized arrangements for a private retirement plan that other plans can't do. You can't do that in qualified plan sectors or in IRAs. So again, there's some uniqueness that this PRP provides to our customers and client base. Okay, let's tackle secret number one. Okay, the first secret is, a lot of you have been familiar with the term that we've been really promoting for well over 5 years now, which is the promissory note. And this is what I call the ultimate capital management strategy. You'll notice that I have capital management underlined because the other secrets do a different type of management and provide different type of benefit. The promissory note, here's our model. And what we're going to do is we're going to look at our client on the left side as exposed, and then we have our protection line, this green dotted line, and on the right, that's the private retirement plan. That's going to be the exempt or protected side of the fence. So again, what you're going to see is you're going to see some movement between the balance sheet on the exposed side and the balance sheet on the protected side to optimize planning. In the way of a promissory note in the model, what a client would do is engage our attorney partners and TRUST-CFO and say, hey, I want to set up a private retirement plan. And then we're basically going to provide an initial analysis. This is always done first step in using our diagnostic exemption calculator online. And I'll reaffirm that at the end of this presentation. And what we do is we come up and become the benchmark by how much can you put in, what can you put in, and what's appropriate. And we don't want to go beyond that, because again, that validates the proof of need. The best person that I know that does this is Jeff Verdon Law. What Jeff does is he does full integrated planning. So he says, Ray, I want you guys to provide us the analysis of a private retirement plan first. I want to know how much I can get in, what I shouldn't surpass. And oh, by the way, when I know that we have exhausted that, now I know I have to get to my other planning and then figure out how to integrate exemption planning with asset protection planning. So Jeff's very good at that, and that's why he ends up being, a consultant to a lot of other attorneys. When we do this and we create the analysis in the box, it never solves all problems. We can only take a bite at the apple that is appropriate. So again, we have limits. So once we've exhausted or capitalized on that, what's going to happen is we're going to have something left over that's still on the client's balance sheet. And those are non-appropriate or non-PRP personal use assets. Things like a home. We can't fund a home, and we never have, into a private retirement plan. It's not appropriate. It already has its exemption in California, a homestead exemption, and you can't double up on exemptions in California. And B, you're living in it as a personal use asset. And there's recent case law in the last 5 years that clients have tried to do that and they've got their teeth kicked in. So those are things that we want to quarantine and identify and inventory on the exposed balance sheet. There are other times when, again, we might not want to fund a private business interest because it's got covenants and restrictions or certain types of banking, provisions that don't allow funding and things like that. So there's some prohibitive, issues. And the same occurs with complex investments. We evaluate those, we inventory those, and we come up with, this has got too much hair on it, it's not appropriate, and therefore it sits on the unprotected side. But what the promissory note does is what I discovered years ago. This is when I first started. I saw a court case, and the court basically said, well, what you put in there is protected, but what you don't isn't. And what they failed to do is identify the future earnings capacity of a client. And a lot of our clients are 35, 45, 55 years old, and they have a huge future. They're making millions per year. And if you accumulate that, it could be 20 or $30 million worth of future assets. And so what a promissory note does is it formalizes and it inventories that future earnings capacity. And we built in the modeling to forecast that and quarantine the value. So what a client's going to do is say, well, not only am I going to fund what I have today and not what I don't have, but I'm going to fund a promissory note of future earnings, okay? And that promissory note is now an asset. But in a private retirement plan, the promissory note as an unfunded asset needs to be equated on its balance sheet. So the promissory note, if I was a banker, which I was, I'd say, hey, listen, Bob Jones' client, we know you're good for it. You're making tons of money. You got other assets, but until such time as you pay it, the promissory note needs to have a secured interest to equate its balance sheet, And B, it needs to have a growth rate because it's an asset of the retirement plan. And that's going to come in the form of an interest payment. So what we do is we formalize the promissory note and we prepare basically the secured interest by taking liens on exposed assets. So this is a way for us to capitalize on the future value of a client's retirement and yet protect current assets as a result of that. It's extremely potent and a great tactic. Again, just formalizing this, a client's going to have to make annual promissory note interest payments. If they don't make that, basically the note is not secured, and that's when an attacker might be able to come in and disrupt this. So we, again, need to make sure our clients can service that note. And how we do that is we basically look at what their capacity is commitment for annual earnings. So every year they're going to be earning money, and we need to know what of those earnings is committed to funding the promissory note. Now that's a good thing. When my real estate developers figure this out, they go, wait, Ray, how much can I charge myself? I want to charge myself 10%. Because why? Because then they can get more money off their exposed personal and business balance sheet and move that money over to their safe pocket. So again, it becomes a good strategy. What we do with those earnings is another question. And this is a model that I'm going to lead into, is that those earnings now have to go somewhere and they're going to grow, and they can grow into the assets that the client has, or they can use those to go fund a new LLC and go buy new real estate. But they basically are going to be reallocated contributions. One of the ways we figured out, again, via banking model, do this is using what we call the private retirement life or PRP life strategy. And the reason is because those earnings, when they come in, they're going to be taxable, just like a deferred comp would. And so it's going to flow through and create tax to a client. And do we want that? Maybe, maybe not. But what we can do with a private retirement life policy is we can take those funds, service a policy where they're already paying premiums to, make sure it's growing tax-free, secure a death benefit, which is a great thing. Why? Because we have a promissory note. If we have a promissory note for $4 million, we really are securing the plan. But if we have a death benefit of $4 million, then should the client predecease that note, those death benefits come in tax-free and pay off the promissory note. And then that becomes a benefit for the heirs. The last thing is the arbitrage you can create with these policies is pretty potent. And so what, again, a policy is going to do, it's going to allow us to take some of the cash values and help a client via tax-free trust loans to continue to grow their world via whether it's business cash flows. Like right now, as you can imagine, businesses are getting crushed with cash flow wise. I've got clients I helped survive in the 06 through 09 crash when they got clobbered and they had no money, and we used all those private retirement plan policy loans and we saved their business. So there's some great storyboarding about which we can do that. Those loans will also be liened, and so we'll protect even more assets. So in totality, if I were to show you this model, your hair probably would have been blown back and said, whoa, this is overwhelming. But when we go through, we can really compress each one of these working components and build the model and show clients how this works. And these are tools that we're going to be providing to our power partners. Just as a side note, we are going to be doing a webinar next month, and it will be on the private retirement plan life policy structure, because that has some depth with what's going on in the stock market right now, as you can imagine. So look for that. Okay, so that's our promissory note model. And this is actually a snapshot of a real case. And this is one we did in December. And what happened was a client, basically, we weren't able to fund enough of the current assets, and they have plenty of earnings capacity. They were actually two tech people working in the Bay Area, making $2 million per year. And we basically formalized and said, well, hey, we can at minimum fund another $2.5 million promissory note. That promissory note actually came back and is protecting the equity in their primary residence, which is a beautiful place in Saratoga. And in the meantime, they're going to service and pay an annual interest of 5%, which is the plan rate. And every year, out of their millions of dollars, write a check for $129,000 and service that note. We use that $129,000. They had a need for insurance anyways, because they had never gotten around to figuring out how to solve that. And we said, we're going to buy some insurance on both of you for $2.5 million using that 129. And what happens is that funding of that 129 times 17 years is there's $2.2 million of funding that's going now, that's being captured over and above the current funding into the private retirement plan. And then how that grows is those values accumulate, and you basically get $3.9 million at retirement, age 60. which is $369,000 tax-free per year. They're going to end up with $8 million over the lifetime tax-free earnings and an additional $12 million of death benefits. So we're providing $20 million or a 10x multiple of benefit over the funding that goes into the bucket. The trick with this is because the private retirement plan and the trust can make these loans without disrupting the plan, we're able to arbitrage and let our clients go and invest. They happen to be investing in some mobile home parks that are doing quite well. And so the client will have that money then they can use and go and invest in those other assets. And so this shows that additional value add of capitalization. So what did I do is I basically took 2.2 million that was exposed, protected it, parlayed it over their accumulation period and their distribution period into $26 million tax-free and creditor protected. Just so you know, we don't just make up these numbers. For our power partners, whether you're an investment advisor, CPA, or other attorney, we provide, here's a snapshot of that investment year by year via accumulation and distribution showing the whole plan. So again, these are the reports and exhibits that we'll provide in perfecting and making sure that it's appropriate asset for a private retirement plan. Okay, I know I'm moving quite quick, but again, these are some good topics that need to be fortified. And again, this will be recorded and all these will be broken down into snippets on topic, as well as the whole recording available for you. And for those that were not able to join us, we'll be able to make sure that they get learned on the topic. Okay, so recapping our promissory note. What did we accomplish? Well, what we did is we were able to monetize future values and use that to protect current assets. Again, a strategy that's not available with other retirement plans. We're able to capture annual earnings and build a tax-free war chest. That's important, and we can devise how much a client wants to do on the earnings. We also leverage what's called a PRP or private retirement life plan via specialized loans to enhance private retirement asset returns. So we're able to utilize funds in PRP when those opportunities arise that are great for our business owners or for private investment opportunities or private equity deals. Okay, now we're going to jump into, and I apologize that I'm not going to pause for questions, but we'll have to tackle that at the end. But what we're going to do is we're going to hit secret number 2. So the first one was capital management strategy. The secret number 2 is called the PRP LLC, and everybody knows what that term LLC is, or at least you should know. What this is going to be the ultimate asset management strategy. So this is how our clients can manage assets. So looking at a private retirement plan LLC model, we're going to first start on the exposed side, and typically a client is going to be setting up, if they have any type of investments or business, they're going to have a limited liability company or LLC. Doesn't matter what state. It can be any state, by the way, California, Delaware, Wyoming, whatever the preference is and whatever their typical planning is. But as our attorneys know, but maybe others don't know, a limited liability company is just that, limited liability. What it's meant to do is carve off the risk of the assets in the LLC from the balance sheet of the client, okay, or the member. The problem is some people, and I met attorneys that literally said, oh, why wouldn't I just set up an LLC in California and protect my assets? Well, because you have inside-outside liability. Just because you have real estate or business inside the LLC doesn't mean it can't get sued. So it's maybe protection, and when clients fund different assets into there, and typically it's real estate that's in there, sometimes there's a myth or there's a fallacy, is the word I would use, that says, oh, I'm protected. So yes, there's a firewall or what they call a corporate veil, but the attorneys that are on this call that I'm looking at their names right now, I guarantee it could bust through that corporate veil. So what we want to look at is, well, how do we truly protect, and the word's going to be exempt, those assets that should somebody want to try to pierce either side of the fence, is have those assets exempt. So what we're going to do is we're going to infuse a LLC and enhance that with a private retirement plan and the private retirement trust that represents that plan. So again, a client's going to hire a TRUST-CFO to set up that plan, and our attorneys to set up the trust, and now that exists. How an LLC can operate is it is actually a diversified model. There are 2 working components. Okay, the first one is member interests, and the second one is a manager. The first thing that we do is we say, well, the member is the owner, And that's different from the manager. And so what it will have is we'll have, if a LLC is existing, we'll assign the member interests to the private retirement plan. So now those member interests aren't owned by the client, they're owned by the exempt trust. And if you're setting up a new, or we partner up with our power attorneys, and the attorneys are setting up a new LLC because maybe it's needed for real estate or investment management or even an active business, then the attorney that would issue that operating agreement would then issue the operating member interest in the form of the private retirement plan right off the bat. There's some tricks to that, and again, we'll escort you with that. But from a high level, what we're talking about is we're talking about member interests that may be exposed to a litigation and the assets to now exempting those assets. So now the private retirement plan becomes the exempt member, the owner. But the exempt member is just somebody that receives the distributions, when they're distributed. They're not the manager. So when we separate those roles and they're clear in the operating agreement, and there's provisions that are specific to an LLC, a private retirement plan LLC, that are different than you might find in a wealth counsel document, or even better yet, on LegalZoom online, the template documents, you need to make sure that these provisions are in there and that these roles are very specific. As the manager goes, what you're going to find is the client doesn't like to lose control. They're going to say, well, I'm managing, Derek in our office has a doctor that has 59 real estate rental properties, and we're not going to manage those. We can't manage those. And he has his staff manage them. So what he's going to do is he's going to have a committee that manages his portfolio of real estate in the LLC, and they take in their income and expenses from the real estate, and they also pay out, they take in the income and the rents from the real estate, but they pay the expenses and they operate the LLC, financials. And he can even take salary. So he can say, listen, I'm providing services rendered. I have a value here. And as the manager, as a non-owner, I want to get a salary. So that becomes a gateway or a spigot by which we can turn on and have some of those funds from the LLC provide a life, income or lifestyle benefit to the client. They also take those monies in the LLC and they typically reinvest, like the doctor. I think it was like 2 or 3 years ago, he had like 25 properties. Now he's more than doubled. He's a bit of a machine. So we want him to manage it and his team to manage that. But the manager does not own the asset. The manager only manages the asset. So if you want to sue the manager, you're going to sue the manager for manager duties. You're not going to sue them for the assets, because the assets are owned by the private retirement plan trust, which is an exempt member. Again, the distinction between exemption is that I have many discharge notices that the courts say, well, we have a claimant and the plaintiff wants to sue this plan or trust, please send us a document, and we send it to them, and then the judge sends back, says, I can't file a suit against this because the plan's exempt. And then the client, or the attacker then has to go through the machinations and wherewithal and decide if they want to spend money to try to look at that plan. Typically, the barbarians just stop at the gates. So again, what we're doing is we're providing an enhanced level of protection and manageability for the client. At the end of the day, what happens is you do accumulate corpus in that LLC, and the LLC will make distributions, and that's when the funds do get moved over. And whether they're end of the year or they're accumulated and spent and then paid off later years, those can be paid then into the private retirement plan. And that's great. Why? Because at the end of the day, the private retirement plan has actually committed to providing a certain benefit, a retirement benefit to the client, the beneficiary, the primary beneficiary of the plan. Until such time, remember, all funds in the plan are exempt. All distributions coming from the plan, if properly administrated by TRUST-CFO, would be exempt, and even death benefits of the passing of the LLC member interest to spouse or heirs, or for the legacy, are going to be exempt. So that becomes a very potent model. We're going to add one other thread to this, which again, this is for the ultimate retirement. Maybe that's 10 years off. Maybe the client's 55 and our plan is to distribute at 65. In the meantime, those distributions are accumulating. And so what we want to look at is how do we mitigate the taxes on those distributions as they're coming in? We're going to show you secret number 3, which is the PRP accelerator. And the uniqueness is the LLC is now an active business. It's managing assets, and that can even be passive assets. And it can then say, well, we want to take some of those reserves and we want to make them pre-tax and set them aside for a rainy day. and that becomes a tax benefit. Because it's an LLC, what happens is those tax benefits that we might create then pass through and flow through down to the client. And so again, we're able to create a flow that is allowing our client to make sure that they're managing and allow us to optimize in terms of asset management and capitalize on all the various benefits at the appropriate time. That's what the LLC model does. Again, it looks a little complex, but if you deconstruct it, you have it, all the working components. And these are all the items, by the way, the TRUST-CFO, the T's and the I's that we trace and we evaluate at each point, and then we document. And that's the value for us as an administrator. Okay, so that's the LLC model. And we're not going to run through any cash flows on that. I'm going to do that in the accelerator. But basically, in a recap, secret number 2 is, as I stole this from Verdon, he has his high sit trust, his have your cake and eat it true. So I'm not violating his trademark, Jeff. But it is a cake and eat it too scenario in terms of asset risk management. Captures and banks profits and distributions for maximum growth, optimizing values, and maximizing our benefits. And then lastly, what it's really going to do, it's going to keep our admin simple. I have a client that has 40 apartment complexes and 40 LLCs. They're not going to hire TRUST-CFO to administrate that inside the private retirement plan and take in and collect all the rents and pay all their bills. We're not built for that. That's not our job. The manager needs to be doing that. So what that has actually done is it's simplified the model and allow us just to administrate the final financials of the LLC that are now owned in a private retirement plan and keep the tracking simple and keep the cost down for our clients. If we get too complex, we're gonna have to raise the price, and it's gonna start thwarting the value to benefit proposition or the ratio. So again, this has been a great way. We're not out to gouge clients, we're out to maximize our value. So we're able to get things done. I have a client that has $65 million in LLC member interest for nursing care facilities, and we charge him $7,500 per year to administrate. And he literally said, that's a deal. He put out his hand and shook my hand saying that's a great deal. So that's what we're trying to accomplish here with the PRP LLC. Okay, and checking on time, doing pretty good. Now what we're going to do is that is on the asset management side. And now we're going to jump into secret number 3 for the ultimate triad. And as you'll notice, the first one is, again, capital management. The second, asset management. The third is tax and cash flow management. So this is the third secret that we're going to capitalize and optimize, called the PRP Accelerator. Usually it's our consistent partners, Cunningham, Reed Scott, Verdon, all the guys that have sent us lots of business over the years that are very familiar with this. And they found it to be a great tool. The accelerator is, as far as I've been in deferred comp and qualified plan administration, it's the most powerful thing developed in the 28 years I've been in the business. And the goal is accelerator. Is what we're trying to do is we're going to actually not only protect and help save taxes, but we're going to help accelerate the growth in the returns of our clients' business. And typically what you're going to find is the proposition that people have is, hey, I can protect your money, but you have to route critical cash flow and capital away from your business to do it. Or I can solve your estate planning, but you're going to have to route critical and cash flow away from your business to do it. Or I can solve your tax planning, but you're going to have to route critical cash flow and capital away from your business to do it. Our model is, no, we can do all those things, but we can also enhance your cash flow and your business capital and returns. That's an unseen proposition as far as I'm concerned. So looking at our client and our exposed to protected balance sheets, what are we going to try to accomplish here? The first step that we're going to have is, again, they're going to say, TRUST-CFO, we're hiring you. We've looked at all the cash flows, and this looks great, and we want a private retirement plan. And then what we're going to do is we're going to say, okay, you client have an active business, and the active business is generating active earnings. And that's going to come in the following forms: C Corp stock, S Corp stock, and LLC member interest. So again, you can have an LLC that owns real estate that's passive, but a lot of clients have LLCs that run active business, widget makers or sales or whatever, okay? These are active earnings. Let me make a statement here. Again, what's the difference between a private retirement plan? You can fund S Corp stock into a private retirement plan. You cannot do it in a qualified plan. You can fund it, C Corp stock in a qualified plan. It gets a little messy, and sometimes it's appropriate, but 95% of the time it's not. Our clients literally could say, well, wait a second, we ask, why are you building your business? Well, because I want to build it and make a ton of money and have a lot of revenue. You're really why? Well, because I want to sell it one day for a ton of money. Okay. And then what are you going to do with that ton of money? Well, then I'm going to live off of it. So if you break it down, why are clients building their business? It's for their private retirement. That's exactly why this was set up in 1970, because California said, hey, we know that these other retirement plans can't fortify these people that are building their private assets. So if you have a private retirement plan, you can fund private stock and real estate and private equity and those assets and make sure they're exempt. Why? Because they're for your retirement. And that's what we're talking about here. This is a step I see a lot of people stepping over, is like they just don't know or don't think that the clients can fund their stock or their member interest, even though it's active and they're an executive, and fund those into the private retirement plan and claim that exemption and protection. Which, by the way, if you're looking at the protection of the core, the asset value, the paper value that you have sitting in the safe, meaning the stock certificates of a corporation or the member interest certificates of the LLC, those things generate profit. In the form of corporations, it's dividends. In the form of LLCs, it's distributions. And so what you're doing is you're not only capturing the current value of the equity of the stock or member interest, you're collecting all the future distributions and cash flows from that. So it becomes an accumulation model. It's extremely potent. So that's a great starting point, but we're not done yet. What happens is when we capture those dividends and distributions, they're taxable. So at the end of the day, what happens is in a grantor trust, which a private retirement plan is actually called an employee grantor trust, not an employer grantor trust. And so everything flows through just as if they'd owned it, and it's funded from their balance sheet. But all the earnings that flow through are taxable just as if the client had owned it. And that's going to be perpetrated through a 1041 tax return that then flows through onto the client's 1040. Okay, and whether that's through a K1 or 1120S, et cetera, that's how that works. So you're not getting any tax bang out of this as of yet, and in terms of a one-dimensional thinking of funding the stock. So that's where we come in. Well, wait a second. The assets of the corporate stock and member interests are now owned by the private retirement plan as the shareholder, and it has a goal. It is incentivized to make sure that that retirement plan reaches its objectives. And there's a lot of volatility in business, as everybody knows, and as we're experiencing with this stupid COVID-19 dilemma, okay? And people are laying off employees, and they're, it's a bit of a calamity, and hopefully we have some rescue with that from the government. But in the meantime, this has a lot of risk. So what we do as TRUST-CFO is we're about risk management. So what we're going to do is say, well, listen, as those distributions and dividends and cash flows come in, we want to set aside some of those, and we want to memorialize and monetize a reserve, a pool of funds for a rainy day to make sure that we know that we're going to have that money for retirement. So what the PRP can do is it can set up a risk reserve pool, and this is buying a special type of casualty insurance called excess and surplus lines. This is not your Allstate. This is not your, INGs of the world. Excess and surplus lines is extremely different. You have to have your own special license, and my underwriters are on the call right now, and they specifically evaluate and look at revenue risk. Now, so this is a key distinction. When you're buying casualty risk, you're buying it, on, somebody slips and falls, I have liability, I have umbrella. Well, that's not revenue risk. Revenue risk is insurance is a total different animal. What you're doing is saying, hey, what if something happens in my business that hammers or eliminates my revenues? And these are more esoteric things and deep thinking things like loss of contract, loss of key employee, trade risk, loss of inventory. I mean, all these things, and a business has an unlimited amount of these risks. And so what we do is we inventory that and we quantify it and come up with what reasonable amount can we provide that justifies the risk reserves, and we underwrite it with my team, and we come up with a solution that is justifiable through underwriting. And so this becomes true insurance coverage. And the good thing is that, again, we can sock away those. We get it on a pre-tax level, so they become deductible. But there is a challenge there. I mean, these premiums are high. So you could have $1 million, $2 million. We did one and then last year, $3 million plus. And at the end of the day, that's great, because what it's doing is it's making these reserves that would otherwise be, or these cash flows that would otherwise be taxable, now pre-tax. The problem is, just like anything else, and I don't care whether that's funding a qualified plan or buying equipment, is once you take those dollars and you fund a casualty revenue risk policy, those dollars are not usable now in the business. So it can be a cash flow crunch. Meaning, if you say, well, I'm going to fund $1 over here and I'm going to get a deduction on that $1, that's great, you save 50 cents, but I spent $1 to do it. So I'm down cash flow. So we've created a methodology through my banking experience by which to alleviate that cash flow pressure. So what I'm going to do is, again, recap here. We're buying revenue risk insurance, creating reserves, a reserve pool. It's true insurance coverage, okay? And this is supported by, it's an A-rated carrier on the London Exchange that's backing us up. It insures against active, passive, and capital gains taxation, but through our financing, our clients will only have to come up with 10% down funding to be able to do this. And this is what everybody does at a fortune levels. They don't write checks for insurance. That's a cash flow killer. What they do is they say, we're going to buy insurance, we're going to deduct it, but we're going to finance it over term so that we basically have our business, our money working in our cash flow. And they create the arbitrage against their business growth versus the cost of monies. So again, what we're doing is we're going to create a TRUST-CFO financing arrangement where we say we will carry the cost and finance the premiums for this over a period of 5 years, and we can renew, so it can be 5, 10, 15, or 20 years, and we're going to do this at interest-only rates, okay? And we don't charge year 1, so it's year 2 through 5, somewhere at a 2.5 to 3.9% interest rate right now. And by the way, don't forget, these casualty risks are deductible, so you got to look at your net cost is somewhere between 1.25% and maybe 2% carrying cost for our clients. The key that I've come up with is, typically when you start borrowing money or financing things, there's additional collateral required, and that starts to intrude on the business lines in that active business. And so what we are able to do is we're able to get the financing arrangements so it's self-collateralized only against the risk reserve insurance, and it does not disrupt or inhibit or intrude, is a better word, on the existing lines and the banking lines that right now the businesses are all going to. So we don't want to suck up that opportunity and dilute their ability to capitalize on debt and grow their business. And so this becomes a self-sustaining model where we can take profits, create deductions, finance it without disruption. Again, I've been doing this a while, even did this in deferred comp, and this is a much better model, non-intrusive model. So again, you can see, again, there's a couple different components that are working together. They're powerful in their own right. And then again, what are we trying to do is we're trying to provide the client with certain things that they're looking for that they can't get otherwise, which is tax deferred capital, which then provides increased cash flows. Then that translates to increased net returns. And it's all risk managed from head to toe. We have it not only creditor protected, okay, at each step, but we have all the risk management lined up so that we don't have volatility in interest rates and things like that. So again, it's a fully risk managed model. Let me show you what this looks like in terms of numbers. Okay, so this is a report. You can actually go online. We have a PRP accelerator calculator now online. Go to the top bar, PRP accelerator. You can go in there and you can enter this and it'll kick out a report and it'll show you the cash flows. And so very simply, this is one we did at the end of last year. It was kind of one of the middle-sized ones. Again, they were typically between $1 and $3 million. If a client has no planning, what's going to happen is if they don't do any planning with this, they're going to pay the taxes regardless. And if they do planning, it's still going to flow through the PRP and they're going to still have to pay the taxes. And you got to be careful there, because if the PRP is capturing dividends and revenues gross, and then the client owes that tax, yes, we have tax burn, but do they have the money to do it? So we got to be careful of the balancing act on that. But now let's look at, well, let's say the client has $2 million out of the $4 million of taxable earnings that we've justified as needs to be a risk reserve, and their top marginal tax rate is at 53%. If they wrote the check for $2 million, they would save, yes, $1 million, but they would be out, or the PRP would be out $2 million. So we're not really solving the cash flow problem. We're only solving a tax problem on an interim basis. So using or leveraging the non-collateral financing that we have, a client would only have to come up with a check for $200,000, and they would be able to borrow that at 2.9% and keep all the money working back into their business. And this client's business was earning 14.5% net ROI. And if I take these monies and I run them through the calculator, at the end of the day, what I'm doing is the client's reinvesting and keeping cash flow going, but they're doing it at a compounding growth rate, which is represented by this green line, and it's compounding every year against a flat tax that may be due in 5, 10, 15, or 20 years, and we can punt it down the line. And this assumes, by the way, that there's no active planning. When we work with our power partners, like, you know, a lot of you guys know Phil Wilson of Markham, Phil and I are very proactive on timing this. So what we're doing is we've got 5 years to strategize how to wipe out and check against that $530,000 that might come back in. And whether that's offsetting depreciation or harvesting tax credits or whatever through the business that's now in the PRP, we're able to make a pretty darn big ding because we have 5 years by which to strategize. Again, three-dimensional thinking, long-term thinking, and when you embed this model, you're getting a heck of a lot of leverage. You're converting the $1 million that you would have paid to the Internal Revenue Service, and 5 years later making $1.2 million out of it, 2.7, 5.6, and then 10.8. Okay, against a $530,000 debt. That's the power of money and compounding. So this again is an analysis that we do for all of our clients that are interested in the accelerator concept. Okay, let me read you, actually, let me take a half step back, sorry. Let me jump into the most potent aspect that we've just launched on this, which is amongst all the risks that a client has, one of the risks they have is that the assets are now owned in a private retirement plan, and the assets have got a huge future value. It's not the current equity only, it's the equity plus all the future growth, and now even more growth that we facilitated but through the accelerator compounding. So we're creating even more value. So the thing is to remember is that this is all done inside the private retirement plan protected bucket. The question is going to be, what happens if something happens to the bucket and somebody gets sued? Yes, it's exempt, but what if there's a nasty enough creditor that wants to come at and they're willing to burn up their cash to try to get to somebody? And let's say a judge says, well, listen, you guys have a ton of money in this private retirement plan. Matter of fact, you did too good a job, and you have even more monies. And I think that, yes, even though TRUST-CFO did a risk analysis and you proved the need for retirement, maybe we have an ultra liberal judge and jury, and they say, well, you guys, we're going to go ahead and say that you guys can keep 80% of that value, but 20% we're still going to award to a creditor because we feel that that's the justification and a need. And there's case law that specifically discusses all this. Matter of fact, one that was in March, the O'Brien case. The risk is theoretically, if somebody's nasty enough and they run a really burn up capital, can they try to get to you? So what we've built, because of all the continuity of this, is we actually have created our own provision inside the PRP accelerator that is a creditor exemption risk coverage. So not only are the assets protected, but all the accumulation and the earnings are protected against a loss of assets and creditor risk. Now, I want to read this to you because this is current and this is now reinsured by an A+ carrier. Loss of creditor exemption rights. So this is the actual provision. This coverage will reimburse the certificate holder for direct loss of asset value, earnings, or litigation costs incurred against a certificate holder in the event of a loss of a creditor exemption lawsuit. Creditor exemption loss includes any loss of exemption benefits, state or federal, where a claimed creditor exemption within a private retirement plan or even a qualified retirement plan is not upheld, and the certificate holder loses assets, values, earnings, and other costs associated with a claim of a creditor from bankruptcy or non-bankruptcy situations and lawsuits. Now remember, in California, we have two systems. One's bankruptcy, one's non-bankruptcy. So again, there's some specifics there that most people aren't aware of. There's some criteria. The losses need to be reported just like you would in a regular casualty. They're covered only if reported within 120 days and the date of the notified lawsuit. So this is extremely, I get so excited, I get beside myself. I shared with Jeff Verdon and one of our new partners, Harry Barth, that this is the most potent thing I've seen in my 30 years, is we actually have an asset protection plan that actually has insurance coverage for loss. And that doesn't exist. Why? Because it's really not asset protection. It's a retirement plan that's claiming an exemption right, and it's fortified. So this is extremely potent. There is a criteria that needs to be noted, that this is only if it's administered by TRUST-CFO. Why? Because we had to go to the carrier and we had to prove our success rate and our validation that we only fund appropriate amount of assets that we can quantify. And that's why they're willing to put their stamp or marker on this, is because we have a high success rate. Okay, so that again is kind of the culmination of the excitement level, at least that I get into. Let's recap the accelerator. It secures against proprietary insurance for real business revenue risks. And again, revenue risk is important to notate versus liability and casualty, or excuse me, liability and other risks. It creates a very large tax deduction against all forms of taxation. I want to stop here. We had a client at the end of last year that had sold her franchises for about between $4 and $5 million. I think it was $4.5 million. She had already sold them. She triggered it. And we took the capital and we funded the capital from the proceeds into a private retirement plan because they were already in the LLC by which she sold the assets. So she just converted the hard asset, the franchise interest, into cash. The tax hadn't been paid yet, but we now have a major risk because she's taken that money, investing it into new franchises. So we actually funded $1,250,000 risk reserve in the accelerator, and we wiped out and checked against a capital gains tax against those proceeds that she had already received. That is extremely intense planning and a very powerful planning. And so again, an example of some three-dimensional thinking on that. Lastly, it uses extremely low-cost financing and arbitrages business cash flows and returns. That's what your client's always going to see in everything we're doing. The people that we're looking to protect, I'm about to talk about the optimization of the client. They come to people and they say, solve my problem, but I want to be in my business because I'm a control freak and I want to run my world my way. And every time somebody in the investment world or somewhere else says, well, I can fix that problem, but you got to go move that capital into my bucket, now you've got resistance. This is the way that you can accomplish both. Solve the problem and let the clients build their world their way. That's our mantra. So if we combine these three secrets, we have an ultimate plan, and that's we're able to infuse a capital management strategy with a asset management strategy and a tax flow and cash flow management strategy, and on a seesaw really figure out what percentage and what is really the need and the want of the client, and solve those by integrating those three strategies. I know I'm running out of time, guys, but again, these are important features that I want to make sure we cover, and then we'll tackle the questions. We have to recap on what the optimal client looks like. And the optimal client is a $5 to $50 million net worth. It's a growing client. So somebody that's going, our bell curve is $10 to $25 million growth curve, with a client that has now outgrown their advisors, has no help. They now totally know that they've got major risks that they've inherited along the way of building that value, and they are lost. And these are people begging for answers. So that's a good one. Coinciding with that, you'll see that 5 million totally generates about 500,000, and you'll see clients making $1 million, 2 million, 3 million, even upwards of 10 million that we have. And the bell curve on the client age is 35 to 55. Not that we can't do lower. We have some young bucks. We also have some more mature people. I've got somebody with 7, 8 years old, and we're still funding a plan. The trick here is really to optimize the planning and the strategies. Is we want about a 10 to 15 year horizon to really compound these benefits. So that's what we look like there. You guys always feel free to leverage TRUST-CFO as your ultimate backroom office source. Again, what we're doing here is we just kicked off an opportunity where we're going to provide you these models that you now can use so that you can explain in layman's terms and boxes and arrows how your client can benefit. And we're hoping that translates and this becomes viral in the California audience, specifically in light of what's going on and the fact that my phone is burning up right now. And I hope yours is too. And then the last thing is, let's not forget boys and girls, that we always start with the diagnostic calculator. TRUST-CFO does not start with anything other than that. We have to have a gateway by which we start, and that's how we do it. You'll see the blue box, diagnostic calculator, everywhere on our website. So please use that, and please have your client complete it. Otherwise, we can't start. Okay, now it's time for questions. I'm sorry I went a little bit over, and I'm going to open it up. And again, if we run short and we close up at 1, then listen, we got plenty of time for emails. But what questions do I see here? We've got a couple. Barry Bosco, okay, can the PRP own a long-term care policy? No, long-term care policy we've not implemented based on just a long-term care policy per se. I've explored it, Barry, because what we're looking at is, okay, you know, how does this relate to preserving retirement assets? That becomes on a smaller scale. What we do have, though, Barry, is on life insurance, we have the accelerated benefits. And since life insurance is specifically an appropriate asset, and it has in obviously cash values, which protected, you know, distributions via loans, tax-free protected, as well as death benefits protected, the accelerated benefits from the death benefits are also inherently protected. Okay, another question, why was tax half of what was due? I think you're probably referring to the accelerator, and when we showed a client making $2 million and then they had a 53% top marginal, we have to look at what the top marginal rate is based on every dollar that's coming in until we chop it down to that lower rate. And when you're into making $4 million, you know, everything at that top marginal rate's at 53%. So that's a model our CPAs will help with. What other questions do we have here? Hopefully everybody's got audio. There was a chat on an audio. Again, everybody, you feel free to ask any questions and shoot those questions if you're more comfortable to my email. And then what we're going to do is we're going to have a Q&A report probably after a couple days, send out to everybody. Here are the assets, excuse me, questions that were asked, and you know, here's our thinking, and here's some tools by which to help. So what we're intending to do is we're going to take this recording and we're going to partition it into segments on topic, and then apply those to when anybody, you know, our clients looking for any type of deeper knowledge, they want to get educated, then we'll have those things applied to the appropriate concept. So again, we're trying to create snippets of collateral, and I'll be writing a blog. I've been feverish on writing blogs. I'm going to be doing some co-op blogs or co-authoring blogs with, again, you know, our power partners, Jeff Verdon and I are going to start writing a few, because we're at critical mass right now. So again, if nobody else has any questions, I think we're coming close. I think we're close to, yeah, 12:53. We got a few more minutes. But again, why does everybody stew on it? I know there's a lot of material to cover, and again, the recording will be available, and you guys can fortify your questions and make sure that they're clear, and I will in turn make sure that the answers are clear. Don't have any more questions coming in, so I think what we'll do is we'll wrap up. Hopefully I didn't speak too fast, but again, I had to stuff the pipe there, and I know everybody appreciates that. So have a wonderful day. Look forward to talking to everybody here soon. Hopefully everybody's healthy and staying in their own little quarantine world until this subsides. Thanks, everybody. Have a great day.